Robbie, come over here. Just steps here.
Mr. Oliver.
Can you guys hear Robbie okay?
Yeah, I can.
Okay. His software's a little handy. Hold on. You guys want to see what he can do? He put a pin in his hand.
I'm out of practice.
Go down. Well, he was certainly a hard worker. What a mess. What a mess you have made of the country. All right. Robbie, you behave yourself. Now, it's a serious topic. Very serious discussion. We'd like your comments. Mr. Robbie, did you bring the PowerPoint? Did you bring the PowerPoint presentation?
I am a PowerPoint presentation.
You were supposed to bring the PowerPoint so that we could fill our time. Is that your You are a waste of space, Mr. Robosigner. Now,
Robots have feelings too.
You know, I want to come back to something that you said, Bill. And Bill asked, is the standard for a debtor's attorney to review the notes and deeds of trust in other cases? And, you know, that may be when the debtor intends to keep their residence. But these days you see people with a lot of real estate. And it may be that you want the trustee to discover a defect and sell some real estate and pay off some priority taxes or some other debt. So just because you find a defect doesn't mean it, Chapter 7 is still not a good idea. And by the same token, I think if you find that defect and decide that you need to file a Chapter 13 case, George, do you think that you have an obligation to disclose that and figure it into your liquidation test?
an obligation is the debtor to disclose the problem, or the debtor's attorney, you mean?
The debtor's attorney, as a Chapter 13 debtor, you have to pay your creditors at least as much as they would be paid in Chapter 7. And if it's the standard of care that a Chapter 7 trustee would find, avoid this problem and pay your creditors, do you not have to disclose that and provide the payment to the plan? I'll pose that question.
That was a very bad question.
Let me try to answer it, Robbie.
Could you repeat the question?
It's a very good question. It has to do with a duty to disclose, a duty to be honest.
I am honest. I was Robo Signer of the Month 2 months in a row. My motherboard is very proud.
How many affidavits did you sign this month, sir?
Oh, my head is ringing. My head is ringing.
You're being... That was Jim Angel.
Darn it, Jim Angel!
I was just trying to verify if that's one of John Berkeley's jogging around.
Yes, it is.
Very, very sad.
It's a good hunch there, Jim.
I signed 7,000 1,000 affidavits in 1 month.
I read about you on the listserv. I read about you from Mr. Gardner. And I think Mr. Esser might have talked about you in a different way.
My uncle, Max,
Max Gardner?
bedroom.
Okay.
Well, Jim had a good case here. Didn't you, Jim? Didn't you have a case involving tenancy by the entire?
Not yet.
George?
Yeah, let's talk about that. Robbie, we're on page 2.
Did someone say page?
Yes, the case that Mr. Angel had was the Angels versus Wells Fargo Bank, and Ray Williams.
Williams case. And was this a property description case?
No.
This case involved a piece of property that was owned as a husband and wife as tenants by the entirety. And the husband had a job and the wife didn't. So in closing, Wells Fargo asked the husband to sign the note deed of trust. Nobody asked the wife to sign it, but she didn't have any income. And Mr. Williams testified at the 341 meeting that nobody intended the wife to sign the deed of trust because she didn't have any income. The Chapter 7 trustee in that case sued Wells Fargo Bank to avoid the deed of trust because under North Carolina law, a transfer of tenancy by the entirety of the property has to be signed by both husband and wife. And the court sustained the trustee's objection and avoided the deed of trust.
Right. Now that is, again, not a unique legal question.
Not a new principle.
You have to, if you have tenants by the entirety property, both husband and wife have to sign in order to transfer interest in the property. But what made it unique in a bankruptcy context, then, I suppose, is the question.
Well, it was interesting. The court, whether or not it needed to, it indicated that reformation was not available even as a threshold matter because there was no mutual mistake, as Mr. Williams had testified, that nobody intended the wife to sign, so it wasn't a mistake that she was on.
What if it had been a mistake? Would they have been able to reform?
I don't think so, and that's getting back to the principle that was expressed in law developers and also recognized by the court in this case that even if reformation had been available as a matter of state law, the trustee's powers as a BFP would have terminated the reformation process.
Okay. Jim, what's the status of that case right now?
It's on appeal and we submitted these to the district court.
On appeal to the district court? Okay.
Judge Leonard actually had 2 holdings. One was based on the statute that those powers have to go into conveyance by the entirety of the property. But he also said that the acknowledgement was defective. It would only have the husband's, it only acknowledged the husband's signature, and based on that,
The acknowledgement being the notary?
the notary part.
Okay. Right.
And therefore, there is cases out there that say if the acknowledgement is improper, that that's not constructive notice of anything. And I think the other thing that's sort of interesting about this case is it sort of shows the extent to which the bank is going to go in order to try to hold the trust, because what they contended is that the trustee was not a bona fide purchaser, that there were little drips and drabs of things in the public record that would have put the trustee on notice that there was a potential by the wife to be part of this trust.
Haven't they raised an issue on appeal about power of attorney?
They have on appeal, they didn't raise it in bankruptcy court, but on appeal they referred to a prior to the trust, which referred to a power of attorney that was not in the record before the bankruptcy court. They contended that the male debtor signing as